Good morning, everyone. My name's Pip Nicholson and I'm the Dean of the Melbourne Law School, and it's an absolute pleasure to be with you this morning. I'd like to acknowledge that I work on the land of the people of the Kulin Nation and pay my respects to their elders past and present, and to their emerging elders also. I'd also like to extend an acknowledgement to all Aboriginal and Torres Strait Islander peoples joining us today. I welcome you very warmly to our discussion this morning: an Australian International Commercial Court, a Quixotic concept or a necessity. This event, as you all know, is a discussion between the Honourable Chief Justice Marilyn and Professor Doug Jones, with moderation provided by Professor John Sharkey. We are deeply honoured as a school and as a community to hear from these distinguished speakers as they share their thoughts on Australia's capacity to serve as a regional commercial dispute resolution hub. Before I formally introduce our wonderful facilitator, Professor John Sharkey, AM, I'd like to deal with a few matters of housekeeping. First, the chat function has been disabled. Instead, we encourage you to submit your questions using the Q&A function. Please submit any questions that you'd like to ask of the wonderful panel. These will be collated and put to the panel as time allows. Today's proceedings are also being recorded and they will be available from our website as soon as we are able to do so. My dear colleague, Professor and Dr. Matthew Bell, will provide closing remarks at the end of the discussion, and we look forward to those also, Matthew. Now let me turn to introduce our facilitator, Professor John Sharkey. John would be known to many of you as an independent arbitrator and mediator, both domestically and internationally. He's also a professorial fellow at the University of Melbourne and state editor for Victoria and Tasmania of the journal Building and Construction Law. He's a former chair of the Law Council of Australia's Construction Law Committee. John was made a member of the Order of Australia in 2006, and in 2010, John was the inaugural winner of the Lifetime Achievement Award presented by Lawyers Weekly. In 2020, John was elected as Fellow of the Australian Academy of Law, and John is a panel arbitrator with AKICA, NZIAC, SIAC, and Africa ADR. John is the former head of the Construction and Engineering Division of Norton Rose Fulbright, Australia, and has practiced construction law, as you've guessed by my introductory comments so far, for more than 35 years. He was the inaugural board member of the Society of Construction Law in Australia, and he was founding fellow of the International Academy of Construction Lawyers. He has sat as an arbitrator and mediator within Australia and internationally on over 80 occasions. He's co-author of Commercial Arbitration, published by Law Book Company in 1986, and Building and Construction Contracts, second edition in 1990. Self-evidently, John's primary practice is the field of commercial disputes in the construction, engineering, energy, and transport sectors. He's a barrister and solicitor of the Supreme Court of Victoria and the High Court of Australia, the Supreme Courts of Tasmania and Western Australia, member of the Law Council of Australia, Law Institute of Victoria, and Society of Construction Law. I cannot think of a better person to chair this conversation this morning. It's with real pleasure that I introduce you and leave you in the hands of Professor John Sharkey, AM. Thank you, John.
Thank you, Pip. I am honoured to be the moderator of this webinar discussion. Our distinguished guest speakers are going to have to forgive me for providing the briefest of introductions to them, but if I was to recite their respective biographies in full, we would take up rather too much of our limited allotted time. So may I first introduce the Honourable Marilyn Warren AC QC, the former Chief Justice of Victoria, who was the longest serving of the then state and federal Chief Justices at the time she stepped down from the Supreme Court, formerly Lieutenant Governor of Victoria and presently sitting as a domestic and international commercial arbitrator. And I should add, presently Judge in Residence at this university's law school. Marilyn's not, I believe, in Melbourne, but I think she is in regional Victoria, where we are sharing the same time zone. Welcome, Marilyn. The second speaker is Professor Doug Jones, AO, who has been a professional colleague and friend of mine for many decades and is probably Australia's best known international commercial arbitrator. But what I think is of particular interest today is his role as an international judge of the Singapore International Commercial Court. Doug has chambers in Sydney, London and Toronto, and it is from Toronto, rather late at night and rather cold, I suspect, that he joins us. So an especially warm welcome to you, Doug.
Thank you, John.
Go then straight to the substance of what we have before us today, Quixotic or necessary. And let me start with you, Doug, and put the question, why should Australia create an international commercial court?
Well, that's a very interesting question, John. If one assumes, as I strongly believe, that Australia can be a regional international dispute resolution hub, we face the challenge which all federations face of having a number of jurisdictions, each with excellent courts and, of course, a federal court. And those parties who would wish to choose amongst the options that an international dispute resolution hub can provide of a court have a rather confusing choice, as they do in the United States of America and in Canada, from where I'm speaking. There has been no really successful international commercial court developed in a federation so far. In the United States, I suppose you have Delaware and New York, who do a reasonable amount of international commercial dispute resolution in their courts, but they have failed to resonate, as has those unitary jurisdictions, obviously England and Wales, and Singapore and other places where a court has been established. So the challenge for Australia, if it is to provide a competitive offering as a regional international dispute resolution hub, is to provide a single source of court jurisdiction to those who come from afar and wish to resolve their disputes in Australia in a court.
Thank you, Doug. Marilyn, I know you have written on this subject. Do you want to try and tackle that question? Mute.
Excitement to enter the fray. Thank you, John. And may I particularly and sincerely thank the Law School and the Dean for the invitation to this exciting topic. My conclusion at the end of the day is that it is a necessity, and I'll set out and elaborate through the course of the discussion why. But I also wish to acknowledge how delighted I am to share a platform with two nationally and internationally acknowledged leaders in the construction and arbitration field. I suggest we need a little bit of history here for those who are not totally familiar with the area and the topic. At this point in time, there are at least 5 international commercial courts. There's London, which has existed for some time, it forms part of the High Court of England. There is Singapore, and we'll talk further, I suspect, about Singapore later, and that court forms part of the Supreme Court of Singapore. There are then the three Middle Eastern courts, Qatar, Dubai and Abu Dhabi. They are largely constituted by retired United Kingdom Supreme Court and High Court judges and senior lawyers and academics. London, as I said, has a long history, but the other courts I listed, they have really come to the fore as a response to the shift in world behaviour, for example, Brexit and China's Belt and Road program. We should acknowledge that there have been other reactions. There are local commercial courts that are prepared to take on this international work in the Netherlands, Paris, Frankfurt, China at Shenzhen and Xi'an, and also in Kazakhstan. So there is a continuing theme of speciality that is being offered. We might note how they work for those not familiar with the operations and ask the question, what is it that they do that current courts cannot do? Well, they operate as a specialist jurisdiction. They sit internationally and they offer to the international market expertise plus internationalism. And where parties wish to choose their forum, it can be a very attractive proposition. What is it that these courts do that local municipal courts can't? Well, essentially, in most instances, it comes down to forum non-convenience. That is, with our courts, such as the Supreme and Federal courts, there needs to be a nexus with the jurisdictions. But the fact is, for the purposes of our discussion, these courts, in fact, exist. And they are an international phenomenon, which I'd suggest it would be very timely for Australia to look at and indeed confront. I have co-written a chapter for a book which I believe has been circulated with my colleague Justice Clyde Croft, and we set out in some detail or elaborate some of the points to be taken into account. But can I just give you, if I might, 10 quick points that may well form a basis for why it is a necessity to have such a court, but these points are by no means exclusive. The first point, it's an obvious one, is that such a court for Australia would provide an alternative or an additional response to international commercial arbitration. International commercial arbitration has been successful across the world and Australia has been an active participant. But there are times, as Chief Justice Menon of Singapore has observed, some cases are better suited to courts for reasons of transparency and open justice. Particularly, I would add, where one or some of the parties are government parties, the citizen has an interest as to what their government is doing in litigation rather than it proceeding behind closed doors in an arbitration. And as Chief Justice Menon has further observed, sometimes there are problems with arbitrations, ethical issues, issues about the qualification of arbitrators, and concerns about rigour and process, and of course procedural fairness. There is, as Chief Justice French observed, also an advantage of potential harmonisation of commercial laws, so we could see a development of international commercial law. Just moving on briefly with my 10 points. Secondly, such a court would expand the range of dispute resolution options. Thirdly, and this is very important for Australia, particularly in the world of the Belt and Road program of China and some political reservations about some jurisdictions, Australia offers neutrality, what is sometimes termed in arbitration as a safe seat. Well, an international court in Australia would offer a safe option to the marketplace. It would also provide an opportunity for Australia to build a reputation for excellence. It would be market responsive and sensitive. We have so many judges in Australia who have so much to offer. It would be an opportunity to create a network, and so Australia would enter the network of international courts and play its role as a global citizen. And it would also be facilitative of transborder activity, which features in so much of Australia's international trade. It is very important that such a court would provide an open court, which is important for the public interest. It would provide choice of forum, and it would be, and we might discuss this further later, a wonderful opportunity for Australia in the context of responding to COVID-19. And then my last point is really, it's a very pragmatic point, I would acknowledge, but I postulate the question, well, why wouldn't we? To which I'd add the adage, build it and they will come. Thank you, John.
Thank you so much, Marilyn. Doug, Marilyn's mentioned the international commercial arbitration scene, and I was going to ask you about what you regard as the key elements of the credible dispute resolution hub that you mentioned. But I'm also going to ask you if a court of this kind is in competition with other courts, and is it in competition with commercial arbitration in that context of the key elements you were speaking about?
Well, John, quite a few of us in Australia, seeing the opportunity that it creates for the Australian economy and for the profession in Australia, have been seeking to develop Australia as a credible and widely used place for international arbitration. And we've succeeded in a number of important respects so far. We have a modern International Arbitration Act, state of the art. We have amongst the very best practitioners in the world here in Australia, many of whom, of course, have had international experience. We have amazing facilities for those who wish to physically come, which of course one can't do at the moment, but which is part of the concept of an international arbitration seat. And there have been, in recent times, a large number of international law firms who have established themselves in Australia with a view to becoming part of the competitive market that we have created in international arbitration. So we need to ask ourselves, what else do we need to do in order to create a credible regional commercial dispute resolution hub? And then answering that question, one looks at the very effective centres in the world where international disputes are decided, of which in the common law world, London is by far the most successful example. And putting it bluntly in economic terms, there are billions of dollars of earnings brought to London by the parties who come with nothing to do with London to have their disputes resolved there. And as Marilyn has pointed out, a court process capable of handling international commercial disputes is complementary to, rather than in competition with, arbitration. It is not something which should be regarded as a competitive process. It provides for parties who wish to have their disputes heard in a court, for parties who have had no initial arbitration agreement but wish to find a credible, neutral place to decide their disputes, to have a forum. And it also provides the opportunity where there are numerous parties involved in a major transaction which has reached the point of dispute, the chance to join parties, which is not possible, of course, in an arbitration where only those who are parties to the arbitration agreement can be involved. So I think it is, to put it bluntly, a no-brainer as the next development for Australia to create a venue in a credible international court to take advantage of what Marilyn has identified as the talent in our judiciary. The problem, though, is that we are quite a regional country. And as one observes from afar, as I have, the approach of Western Australia and Queensland in particular in response to the COVID-19 pandemic, one sees the regional rivalries writ large. And so it is, sadly, in the law. When I first started practicing law as a Queensland lawyer, people from the south were not admitted to practice in Queensland. And so it also was in Western Australia. Lawyers are as protectionist as any industry you can think of. But in Australia, we have managed, against the flow of the selfishness of local practitioners, to build a national profession. We have not succeeded, apart from the Federal Court of Australia, to build a national judiciary for very good constitutional reasons. And there's nothing that I'm suggesting which would lead to the demolition of our existing structure. What we need to do is to find a way to bring strangers to Australia to a court which they can understand clearly, represents the very best of the judicial talent available in Australia to decide their international disputes, should they choose that option.
Thank you, Doug. Your last words were, should they choose that option? Can I put it to both of you that that involves making a choice of what I'll call Australian law? And how do we advance that in a way for parties to regard the adoption of that particular choice of law as preferential to other options?
Well, John, if I might respond initially, but before doing so, for completeness, we should acknowledge that there has been reticence expressed about the whole concept of an international commercial court. So, for example, Justice Bell, the President of the New South Wales Court of Appeal, has written a paper which is available in the Australian Law Journal, and I don't profess to summarise all of his honours points, but of a couple of salient points to mention. It is said that we have the judicial expertise here already in Australia, therefore we don't need such a court. And the point is, or focus is directed to the, for example, the commercial list of the Supreme Court of New South Wales, the commercial court of the Supreme Court of Victoria, and the commercial division of the Federal Court of Australia, and other lists in other superior jurisdictions. And so it said it's unnecessary. Why would that be done? Well, the point is that there are times when international parties can't come to Australia as a matter of choice because they do not have that nexus I mentioned with the jurisdiction. That's an important point, but we can talk further about the necessity. One other observation I'd make is picking up on Doug's point about the superb judicial expertise that we have here in Australia. We should be mindful of the fact that there's a fair amount of it operating offshore. That is, some of our eminent retired judges of the higher courts are in fact sitting on some of the international courts. And it just logically seems to make sense. Why can't they sit in their own jurisdiction? The other reticence that is sometimes expressed is, well, in Australia we are a federation and we just can't do it. Well, I would say that it's a matter of drafting, working these matters out, and I'm sure that the eminent constitutional law scholars of the Melbourne Law School could resolve the sorts of difficulties and Chapter 3 matters that might be raised. But returning to the point you raised, John, why would people come? Well, I would point out two reasons in particular, or three actually, three. The expertise that Doug mentioned, the safety of and competence of the jurisdiction, but also at this point in time, the matter of the technological experience that Australia has had. Our commercial courts have performed brilliantly in terms of making the switch from bricks and mortar court functioning to technological digital functioning. Our judges, our courts would be ready to transpose that experience and that technology into a central location for the purposes of functioning of an international commercial court. It's a very important point at this time. And then lastly, in direct response to the point you raise about arguable difficulty as to countries coming to Australia and being subjected to Australian law, well, a couple of ways I'd respond to that. In some of the international courts, the way around this has been for the courts to apply the law of choice of the parties, and that's an obvious ready solution. The second, and I have absolute confidence in the Australian judiciary to be able to deal with that. And secondly, there is, it really comes down to marketing. As confidence grows in this international court, as I said before, build it and they will come. There are difficulties at London, there are difficulties in New York because of COVID-19. If people are prepared to deal with Singapore, it's not much further to the national grid of Australia. And Australia can offer, we shouldn't think of things as being one city-centric. Australia can offer a national grid. So a offshore gas matter could be heard very readily in Darwin or Perth, and other matters could be readily heard in Brisbane, Sydney, and so on. So I do see that if Australia embraces the opportunity and inserts itself into the international marketplace, it will be a success and they will come.
Thank you very much.
John, it's an interesting question about Australian law that you raise. As with Marilyn, I don't see an Australian commercial court necessarily applying Australian law. The sad thing, though, is that there is no Australian law. In arbitration, arbitrators have as their seat for the arbitration, the juridical home of the arbitration, places that are often, more often than not, different to the party's choice of law. So that one hears in London cases involving Saudi law or the law of Pakistan, and that is part of international dispute resolution. So parties have two choices to make. They can choose their forum or type of dispute resolution, arbitration or court, and they can choose their law. Now, one of the obvious advantages, sadly for Australia, is that Singapore and England have a system of law well known and respected amongst those who choose common law systems of law to govern their disputes. For those transactions that I did when I was a transactional lawyer, involving parties from outside Australia, when the debate arose as what law will we have to govern the contract. The eyes glazed over when one discussed a choice between the law of New South Wales or the law of Victoria or the law of Western Australia or the law of the ACT. They were simply disinterested in understanding that there weren't an awful lot of differences between the laws, but that there were separate laws to choose. So for international transactions, there is yet another issue that we have to face in Australia, which I have myself written about and promoted, and that is the creation of an Australian commercial law, which deals with such funny things as the Australian consumer law, which a lot of overseas parties find quite disconcerting. And we could use that to also attract work. But I don't think you need to assume that an Australian commercial court would need to apply the law of New South Wales, Victoria, or Western Australia. It could apply the law of Singapore or the law of England or the law of Japan, if that is chosen by the parties. Indeed, in my role as an international judge in the Singapore court, we have the power to determine that when the Singapore International Commercial Court is asked to decide a dispute other than under the law of Singapore, we can hear that by way of submission rather than by way of evidence in the way in which common law courts have generally approached what they call foreign law.
So, Doug, I'll go to Singapore if I can straight away. Marilyn's mentioned some of the other models. You have a Singapore hat on. I understand that. We all understand that. But is there a particular model that you think is appropriate for Australia to consider in this present context?
Well, Marilyn has identified a number of different types of commercial courts that have grown up in recent years. For the sake of being slightly pejorative, I would put them into the following categories. Firstly, the Brexit wannabes. Germany, France in particular, Holland as well, have sought to set up commercial courts attempting to have proceedings conducted in English in order to take advantage of the fact that England has left the EU and they have a chance to get some of the slice of the action that they see London has had for so long. So that's one category of commercial court. The second category of commercial court are the courts that have been set up in places where parties aren't necessarily comfortable with the local courts, Kazakhstan, the Middle East and the like, and where there has been established what one could call, without in any way being critical, a little England, applying English law with retired senior English judges manning the courts. The third category of commercial court are the courts which have been established as part of the jurisdiction of an existing credible court. Most obviously, the High Court of England and Wales and the commercial court of that court. Secondly, Singapore, which is part of the High Court of Singapore and exercises the jurisdiction of the Singapore court, about which there can be no doubt regarding its reputation. Australia would, in my view, fit into that third category and be potentially the third choice of international commercial court in the world. But it would need to establish that it grew out of and was part of a credible Australian judicial system. How that is done, as Marilyn has pointed out, in a federation, and as I've observed as a challenge of a federation, does have some constitutional complications. They're not insurmountable though. And rather than throw up our hands in horror, as has been done when the suggestion that Section 92 might allow a certain litigant into Western Australia, but politically unacceptable to run the argument. Let's not regard it as too difficult a question. Let's move forward with a common purpose in the interests of the development of Australia in this area.
Doug, thank you. I'm going to stay with you for a moment. Marilyn's has addressed what I'll call the no case, with which we're familiar, and that runs, as I understand it, that we've got existing successful commercial lists in the state Supreme Courts and the federal court. We don't need an international court of this kind. Do you want to just speak briefly to that point, please?
They are excellent courts, well known by Australians. Not so well known outside Australia. And for any one of those courts to think that they would be able to create the international cachet, say, of Delaware or New York, is, I believe, an exercise in self-delusion. Secondly, if there was established one centre, say the Federal Court of Australia, although it's got jurisdictional issues in that respect, or the Supreme Court of Victoria, that would automatically exclude from the application of talent all of those really bright commercial judges in the other states. And we would not be deploying, to the advantage of the concept, the judicial talent we have available in Australia.
Thank you. Marilyn,
John, could I just touch on a couple of things Doug has mentioned? We already have experience in Australia of judges operating on what might be called a cross-fertilisation basis. So, for example, sometimes there will be a particular test case or there will be conflict difficulties. And so judges from another jurisdiction will sit on a trial or an appeal, the judge being appointed and having a dual commission for that purpose. We also have a very popular phenomenon in the courts in Australia these days, the use of retired judges, they being appointed as reservists. And so you have retired federal court judges being appointed, for argument's sake, or experience shows, to the New South Wales Court of Appeal, and in Victoria similarly, and in other jurisdictions. So we have already demonstrated a flexibility in moving across the border, and in my judicial experience, judges relish the opportunity. The other point I did want to touch on that Doug raised, and it is important, the opportunity for Australia to develop an international commercial law. I think that is a very exciting opportunity, but also I would say it is part of Australia's progression to maturity to embrace the development of such an international commercial law rather than the law of New South Wales or the law of Victoria and so on, or waiting in the limited number of cases that go to the High Court for the commercial matters for the High Court to dispense what the new principle might be. The point I would make is this, and it's sometimes forgotten, when the choice of forum convention was tabled in the Victorian Parliament in 2016, there was a document entitled the National Interest Analysis. And in that analysis, and this is in the Australian Parliament, there was an acknowledgement that if Australia signed the choice of forum convention, there was an opportunity for Australia to embrace a new international civil law. So my point is, it is there, it has not yet been picked up, and there is an opportunity for institutions such as the Australian Bar Association, the Law Council of Australia, to encourage the Commonwealth Attorney General and the Commonwealth Shadow Attorney General to look at this prospect, which I would suggest seems on the face of it to be very much a bipartisan opportunity that fits in seamlessly with Australia's trade and diplomatic aspirations.
Thank you very much, Marilyn. While you've been speaking, participants have been in a few questions. Draw from them some of them in the time that remains. Doug, this is about appeals, and is there an appeal within the Singapore framework? And if I can add my own, I assume that there is. And is there need for special leave applications, is what I'm particularly thinking of, in any appeal process?
There's an appeal as of right, unless the party is excluded by agreement from every decision of the Singapore International Commercial Court. There is a choice, well, there's a judgment made at the time a court is formed for a particular dispute as to whether the first instance court will be a bench of 1 or 3. But the right of appeal, unless excluded by agreement, is to the Singapore Court of Appeal. And in the event of an appeal to the Singapore Court of Appeal, if the bench has been constituted by international judges, an international judge will sit on the appeal in the Singapore Court of Appeal. And
is there a special leave process?
No, it's an appeal as of right.
Appeal as of right. Thank you. COVID-19's already been mentioned, and I think all of the papers that have been written on the topic of an Australian International Commercial Court were all written, as far as I'm aware, more than 6 months ago. And of course, we all know what's occurred in that time. Before 6 months ago, all court hearings, almost all, were physical. What we have seen is a world that's changed from one where physical hearings are almost non-existent. And you mentioned geography earlier, Doug. Does the pandemic work in Australia's favour in relation to the attractiveness of an international commercial court here?
Well, we used to have the tyranny of distance. We now only have the tyranny of time zones. Yes. So I think we can, as Australians, operate far more flexibly than many were able to do previously in a virtual environment. It won't always be virtual, of course, and I think the advantages that we have in Australia that Marilyn has referred to, of being at the leading edge for many, many years of electronic hearings and now virtual hearings, gives us the opportunity to build on the developments that have occurred of necessity in a virtual hearing environment during COVID-19 for the future. But we cannot ignore the fact that there will be some physical element to cases in the future when the virus goes away or there is an appropriate remedy available. And we shouldn't flinch from saying that Australia is a great place to come to. And if you have a whole range of things to do in a case, you don't need to come for all those things. You can have virtual and effective case management conferences and the like, and Australians are well placed now and will continue to be well placed to take advantage of that technology.
Marilyn.
John, can I just add, we should not underestimate the level of skill and expertise that now exists in our commercial courts in Australia it is truly quite sophisticated. I speak particularly from the experience of Victoria, but my understanding is things have gone very well in New South Wales and federally, and I'm sure in the other jurisdictions with which I'm not currently familiar. But in Victoria, anybody who has any doubt about this can tune in, as it were, to use an old-fashioned term, to a commercial trial being run in the Supreme Court of Victoria Commercial Court and see the extent and the capacity of the judge to be flexible and adaptive. All documents are filed online. There's use of multi-screen techniques. Counsel are entirely digital, as are the instructing lawyers. Witnesses in commercial cases, particularly that kind of evidence, is amenable because it's already largely documentary, so that is all done. So in effect, what has happened is that the commercial courts have stepped up, and I have no doubt that Australia is a world leader in that respect. Of course, it's had its challenges. As a judge, if there was a credit issue in a case, you would have to adapt in terms of making an assessment of a witness through a screen. And similarly for counsel, cross-examining a witness, it's a whole new challenge, but people are rising to that challenge. So I see Australia being very well positioned because of COVID-19 to offer itself. There's one related point I would particularly make. At this time, the Prime Minister, the Premiers and the Chief Administrators are calling for innovative and stimulating ideas to develop the Australian economy and the state and territory economies. It does seem to me that there is an opportunity here for the institutions I mentioned earlier to put a proposal to government which would be very attractive and effective for all the reasons we are discussing this morning.
Thank you, Marilyn. We've got about 5 minutes and we've got a few more questions that would be, I'm sure, of interest to all participants to be aired and to obtain the views of our speakers upon. One question is about enforcement. We have not, as a nation, signed or acceded to the Hague Convention on choice of court agreements. Is that a step that is thought has to be taken before you would have an international commercial court? Doug, do you have a view about enforcement?
Enforcement's an interesting question. It's been looked at very closely by the Singapore court in the context of the enforceability of judgments of the Singapore International Commercial Court. That court proceeded in its early days by way of memorandum of agreement with other courts. And it has memorandum of agreement with a whole range of courts from around the world. And interestingly, successful enforcement of its judgments in Vietnam, in China, and in other countries which you might regard as being slightly more user-friendly in terms of enforceability of awards. Of course, before the New York Convention, all arbitration awards had to be sued upon. And the process for enforcement of a court judgment is exactly that. It's not the most complex process that some proponents of arbitration would have you believe. The process of enforcement, although rightly to be compared to the New York Convention for Arbitration Awards, is certainly not irredeemably difficult in the absence of a Hague Convention. And I think the Hague Convention is still is still a work in progress, shall we say.
Marilyn, is there anything you wanted to say on that particular point? And it might have...
No, I say that I would embrace what Doug has just said. And also, I would add, in terms of developing the legislative model to facilitate an Australian International Commercial Court, there would have to be consideration of a package, as it were, as to such as the Hague Convention and the choice of forum convention and so on, as to how that is to be managed and whether Australia would become a signatory.
Thank you. I'm just looking at what remains. Some very short questions I'm going to go to. Doug, rights of audience in Singapore, and how would you see them being? What lawyers are able to appear as of right in an Australian International Commercial Court?
Well, the position in Singapore is that there are a significant number of international practitioners registered as practitioners of the Singapore International Commercial Court, and they have a right of audience. They have a right of audience alone where the law being applied is not the law of Singapore, or where the law to be considered is a law other than the law of Singapore in conjunction with the law of Singapore. However, where the law of Singapore is being applied, the local practitioners have a right of appearance and must appear along with colleagues from other jurisdictions if appropriate. Now, that is a step beyond where we are in Australia in terms of court appearance rights. And it's something that would need to be considered. The views of the profession need to be taken account of, but you may well recall the need in the International Arbitration Act to explicitly provide the right to appear in international arbitrations in Australia, irrespective of any state law society or bar restriction in that respect, which was no doubt introduced to avoid long and perhaps barren debate with the local profession. But my view as an Australian practitioner is that the more international practitioners come to Australia, the greater the opportunities there are for Australian practitioners. And we should not take a narrow approach to the right of appearance, in my view.
John, to which I would add, because so many of the law firms function in Australia on a global international basis, it makes sense for those global firms to be able to bring in international lawyers and for Australian lawyers to go and appear internationally in other fora. In terms of right to practice, we do already have in Australia the uniform legal profession laws where there is the joint operation between Victoria and New South Wales. And I'm sure that there could be local arrangements made with other state jurisdictions, bearing in mind the point I made a moment ago. If this legislation came to fruition to facilitate the International Australian Court, there would be a package of measures that would need to be included or visited, which relate to other parcels of legislation.
Good. Look, thank you both. There are many other questions that have been raised, and I'm sorry to the participants that we've not been able to get to them. I think the last remaining task that I have for the day is to hand over to Dr. Matthew Bell, who's going to make some concluding remarks.
I do so with great pleasure. Thank you, John. So I don't need to tell anybody here that this has been an extraordinary year. We've all been making decisions and thinking about possibilities that a year ago would have seemed extraordinary. One of the decisions I had to make, of course, was what Zoom background I might have today. And so I thought I'd take us all back to where it all started from the university's point of view in the old university quad. So not just I, but thousands of my fellow Melbourne Law School graduates have learned about law in that quad. And it really represents, I suppose, the heritage of the university, and we've been able to bring to bear the expertise that is so much a part of that heritage today, and I'm very, very grateful to that. But the main thing I really want to thank all of the panelists for is you've also explained to us what the future can look like, and that's the thing that's always, of course, extremely exciting for all of us and for our students as well. So you've and today is, of course, a happy day for us in Melbourne because we're finally coming out of lockdown. I think there's no better day in which to be thinking about what the future might be bringing. So Marilyn, Doug, John, thank you very much indeed for exploring these possibilities and for all that you've done to prepare for this, not just over the last few weeks. There's been a lot of work involved in that, of course, but lifetimes of experience that you've been able to bring to bear to us today in this webinar. I also want to thank, of course, my Melbourne Law School colleagues for everything that was involved in bringing this webinar to us today. My colleagues Dorothy No and Murray, and of course to our Dean, Professor Nicholson, for her support throughout. And to everybody who's joined us on this webinar or might be watching it afterwards, thank you very much indeed for joining us as well. As John said, we've had some terrific questions, and sorry we're unable to get to all of them during this session, but I'm very confident from the looks of those questions, especially the ones about new technologies, blockchain and other things. I'm very confident that the discussions that we've started today will be continued in social media and articles and many other forums to come. So to all of you, thank you very much indeed. Thank you for joining us today, and we look forward to seeing you again in a Melbourne Law School webinar.